So the process to make your property smoke-free in common areas. And this is, your building hallways, your lobbies, any parkland, any, property we have outside around your entryways. This is generally something that a board can accomplish by an amendment to the house rules. Boards generally have the authority to do this unless you're in a very unusual building where for some reason in a condo, the declaration and the bylaws, or in a co-op, your proprietary lease has some specific language that would require you to allow smoking in common areas. I haven't seen that, but it's conceivable that, J.R. Reynolds built a condo and developed it for smoking everywhere all the time. So these rules don't just have to be limited to you can't smoke in your common areas. They can also extend to requiring those who do choose to smoke to take reasonable steps to prevent their smoke from infiltrating other units, other apartments, or the common areas. And we can talk later on about some tools for doing that. So if you're in a condo, the board's going to generally have the power by a board majority vote to amend and update your house rules to bar smoking in common areas. Once the rules are updated, usually by a vote that's reflected in your board meeting minutes so that we know when it happened and how it happened, the updated rules should be circulated to the unit owners and they're then enforceable consistent with the rest of your documents. It's important to be sure that they're circulated. It's also important if you're revamping your house rules to look at them holistically and see if maybe there's some other little issues we need to address at the same time. So we're not amending one rule and then another and then another. Do a new consolidated set. The process is essentially the same in a co-op. It's important to remember in amending your house rules what I alluded to moments before. You can't contradict the more significant documents. So if you're in a condo, your house rules amendment can't contradict the bylaws or the declaration, right? They're a subordinate document. In a co-op, you have the same situation, except you can't contradict your proprietary lease. Bear in mind, too, that there are some courts that have determined that attempted clarifications or supplementations of governing document provisions, when you attempt to do that in the house rules, is actually an implied contradiction, and they might throw it out in the event of a challenge. So you want to be careful, you want to talk to your lawyer, but generally in common areas, the board can do it in the house rules. Now, if we want to make the building entirely smoke-free, right down to the inside of every apartment or unit, it's a little bit more complicated, but certainly not impossible. And I'm speaking about condos and co-ops here, to the extent we're talking about a rental building that is owned by an individual entity, or if we're a developer making a new building, there's nothing to stop you from day one just declaring this as a smoke-free building entirely. We don't have to worry about this. But most of you are not in that situation. We're looking to make an existing building less smoky or entirely smoke-free. Boards generally aren't able to, by a house rule amendment, ban smoking in the interior of units and apartments. Instead, we do this by an amendment to the governing documents. The process is very similar in both condos and co-ops. Generally, amendment requires a vote of 2/3 of the shareholders or the unit owners. There are some details that are a little different between the two. But it's important to check your documents because sometimes you have a higher threshold for amendment. Sometimes it's 75 or even 80%. But most of the time we're talking about 2/3. The process in a condo is that an amendment, once passed at a meeting, that it has to be recorded. In a co-op, it doesn't actually have to be recorded. But in both contexts, you're going to check your documents to make sure of the notice requirements, bearing in mind that notice requirements are sometimes different for an amendment. For example, you may have to issue a notice of meeting for a regular annual meeting 10 to 30 days, but in the event of an amendment, you may have to give 30 to 50 days. Where you're amending your documents, you also always have to provide the full text of the proposed amendment with the notice of the meeting at which the amendment is going to occur and be voted. There's a vote of the unit owners. You have to meet the threshold of you have to meet quorum, obviously, but also the threshold that is required for the particular amendment to pass in your building. And then in a condo, it has to be recorded, and in the co-op, it does not necessarily. Amending your documents is a political process as much as a legal one, right? So it's important, if a board is making the decision that we want to present a completely smoke-free amendment to the documents, that you give your unit owners and your shareholders an opportunity to ask any questions they might have, an opportunity to be heard on whether we should do this or not, and to allow them to feel consulted and fully responded to as part of the process. It may make sense to schedule in advance of the actual amendment meeting. It may make sense to schedule, town halls or informational meetings, have somebody sitting a table in the lobby. There are lots of mechanisms that we use both to inform our shareholders what's about to happen, or our unit owners, depending on what you are, and also to gather proxies from the folks who may support the amendment, but they're not going to show up to the meeting. Because amendments have a higher threshold, a higher voting threshold to pass, it's even more important than with your regular election that you do your proxy campaigns if you have to. Even if we go through the whole amendment process, sorry about that, do it right, do it perfectly. There are certain circumstances where the amendment might not be effective or enforceable as to particular residents within your building. This is going to be true if you have rent stabilized or controlled tenants in owned apartments. The terms of those tenancies are going to continue without regard to any amendment. So even if you make your building fully smoke-free, it may not be enforceable against long-term tenants in certain situations. In addition, the legalization of marijuana and the fact of, or the existence of marijuana for medical use means that the board might be required to grant an exception, even in the event of an amendment, to a rule that bars smoking in an apartment. If there's someone who comes to the board and says, look, I need an exception, I'm entitled to this because I have a disability and this is a necessary, reasonable accommodation for my disability, that I be allowed to smoke. That doesn't necessarily restrict us from taking measures to prevent that smoke from permeating the rest of the building, but there is going to have to be room for exceptions in certain circumstances. To hit a couple of the relevant statutes before we get to the Marijuana Legalization Act, there are two relevant statutes. The main one for us here is the New York State Clean Indoor Air Act, New York State Public Health Law, Article 13-E. Now, this generally permits smoking in private homes and residences that aren't used as daycares. It doesn't prohibit a board from restricting that, but it does generally allow. It prohibits smoking in places of employment, which, let's remember, as condos and co-ops, we often have employees. So state law is going to bar smoking in the workplace. Doesn't extend to the apartments themselves, but in the common areas, particularly in the areas frequented by your porters, your superintendents, et cetera, smoking is absolutely barred, even if the board doesn't pass a rule. State law would also bar smoking in enclosed indoor areas that are open to the public that contain a swimming pool. Maybe unusual that a condo or a co-op would have a swimming pool open to the public indoors, but not impossible. I also include here youth centers, though it's unusual. Every once in a while you have it. I do hope I don't have any folks here with zoos or bingo halls in their condos or co-ops. It's also worth noting that the New York State Clean Indoor Air Act prohibits smoking within, 100 feet of entrances to schools and playgrounds when children are present. If your building is located near a school or a playground, it's worth noting that regardless of what you do, smoking is still likely prohibited within that radius. The New York City Smoke-Free Air Act goes a little bit further, and it actually requires boards to adopt a smoking policy, which is not required throughout the state, and I don't believe required by Westchester County, but it does go further there. And it goes a little bit further in that it would bar smoking in playgrounds, pedestrian plazas, and parks. A lot of our buildings might have sort of a courtyard and that sort of thing. If you're in the city and it could be considered a pedestrian plaza, you might be required to bar smoking in that area. If you're outside of the city, that's not a concern. And now we get to the last of our statutes, the New York Marijuana Regulation and Taxation Act, MSRT. So this act became effective in March of 2021, and by its terms allowed for the immediate use of recreational marijuana by people 21 years and older, but no legal sales until the Cannabis Control Board was formed, organized, and issuing all the necessary licenses and promulgating regulations. That took a while, but as of April of 22, CCB had granted and approved 52 recreational cannabis licenses statewide. And it issued the first 36 adult use retail licenses in November of 22. Now, those licenses were issued. That doesn't mean that the businesses actually opened their doors. But the first legal purchase happened at the Housing Works dispensary in Greenwich Village, December 29th of 2022. But now, a year later, there are only 27 licensed shops and delivery services that are open, which is far less than anyone expected. Part of the reason for that is that the whole program has been embroiled in litigation concerning who can get a license, who has priority to get a license, and who is going to grab at this new available pot of money, frankly. Now, all this licensing has been mired in litigation, primarily two cases that I'm not going to get into the details of tonight. But there was a major settlement just this Monday of two of the major cases. That ended a 3-month freeze on licensing. And while there was a 3-month freeze, there was also more drag because everyone was waiting to see what was happening with the litigation, right? So that 3-month freeze should be ending very soon on recreational dispensary openings statewide. There were, as I understand from the Times reporting, there were 436 retail license holders that are sort of in line to open shops and make deliveries whose applications were frozen at whatever stage. About 50 to 60 of those are ready to open immediately. So we can expect the number of cannabis dispensaries and delivery services that are open for business to triple, nearly triple, in the next couple of months. Now, this is likely less of an issue in, Westchester and upstate areas because we have a lower concentration of condos and co-ops that have commercial spaces on the ground floor. But this is going to become a tremendous issue for some of our city buildings. My firm has already been involved in at least 2 or 3 lawsuits concerning tenants coming in pretending to be one sort of store, but with a cannabis license on the hold. And, many condos and co-ops legitimately aren't interested in having a dispensary on the ground floor. So this is about to explode, which is always nice to know before it actually does the exploding. So aside from litigation concerning whether you have a dispensary on your ground floor, what does MSRT mean for our condos and co-ops? Not too much, given that we had medical marijuana prior to this. Marijuana use is now legal, but we can regulate in the same way we do smoking anything else. We do need to be aware of the possibility that we'd have to grant a reasonable accommodation to a smoking prohibition for someone who uses or smokes medical marijuana. To the extent we have employees, we do need to revise employee testing policies. The statute allows employers to require drug testing and random testing, including marijuana testing. The problem arises because you can't really do anything for a conventional marijuana positive because that use may be legal and the New York labor law does not permit disciplinary action or a failure to hire due to legal off-premises use, right? So a failed drug test for pot is not a disqualifier. But that doesn't mean you can't do something if you have an employee who shows up incapacitated by marijuana, in the same way that you can discipline an employee who shows up drunk to work. But you can only discipline in either of those situations if you can demonstrate that impairment. For marijuana in particular, we can discipline and take adverse action if an employee displays specific articulable symptoms reflecting impairment at work. And we should consider updating our policies if we haven't already, certainly consulting with BRI and looking at our CBAs to make sure what is permitted, but also consider being sure we're training our supervisors to properly recognize, and the key is to document the signs of an employee who shows up stoned to work. It's worth noting very briefly that marijuana, while legal in states, is still illegal under federal law. It's still a Schedule I substance under the Controlled Substances Act. That puts it right up there with heroin, cocaine, LSD. While there is a recommendation from the Department of Health and Human Services to downgrade it from Schedule I to III, that would put it in categories with things like testosterone and Tylenol with codeine. That proposal hasn't been acted upon yet. And that's the formal proposal, I think, came through in August of 23. It's been talked about for years, but as legalization efforts go up, but it hasn't been downgraded yet. There have been numerous different proposals. PowerPoint is not my superpower, folks. Sorry about that. There have been numerous different proposals in Congress to legalize marijuana on the federal level, or at least defer to the state's legalization of marijuana. None of them have gone anywhere. We have the various incarnation of the States Act, which is an acronym for strengthening the 10th Amendment. In various other, various formulation, we have the states reform, I think the State Act. These all federally decriminalize cannabis under the guise of deferring to state regulation. Some just cannabis, some go beyond cannabis. The Marijuana 1 to 3 Act of 2023 is a very narrow act that would just reschedule cannabis from Schedule 1 to Schedule 3, consistent with the Health and Human Services recommendation. Also hasn't gone anywhere. The Marijuana Opportunity Reinvestment and Expungement Act, is known as the MORE Act, has been around since 2019, 2020. It's passed the House a couple of times. This is the comprehensive bill that would end the federal prohibition of cannabis. It would also end all criminal penalties or federal criminal penalties and expunge past convictions. So that includes all of the criminal aspect of that. And the one of these statutes or these proposals that seems to be going somewhere is the banking one, the Secure and Fair Enforcement Banking Act. This has passed the House 7 times, but the Senate hadn't taken it up. The Senate has now just, I believe, this year or perhaps late last year, proposed a new version that's very similar, but is known, the House version was the SAFE Act. The Senate's version is the SAFER Act. But it just passed the Senate Banking Committee earlier this summer, no, in September of 23, and we expect it to be moving to the Senate floor hopefully sometime in 23 or 24. The SAFE Act protects banking institutions and enables them to lend to cannabis growers, retail merchants, etc. One of the difficulties of the legal cannabis market is that because cannabis is illegal on the federal level, there are various restrictions that prohibit banks and impose sanctions on banks for lending to support illegal activity, essentially. This would remove those banking restrictions on a federal level, allow more and lower interest money to flow into the industry.